The last I mentioned that Article 4, 5, and 17, you should always prepare for them. Even if you don't get further lessons, or you are unable to attend classes for then the rest of the period, you should always prepare to meet questions on Article 4, Article 5, and then Article 17. So I thought that we should bring these questions so that we'll see how we can answer them, assuming we are in exams mode and this is where we are supposed to end. So I brought Article 4 questions, A and then B. And the A was on Mosin Limited. The A and B are the same. So if you have done the BA, you should be able to do the B as well. Then I also shared a question on the 10-keep Article 5. This one, we agreed to do it as an assignment. And so I may say I'm still expecting this assignment if only you have read the case we shared, because it's based on the case. So maybe I will skip this one for today whilst you promise to deliver your answers for this particular question. Then I think I brought another question, which is on Article 17. Article 17. So we'll go through question 1A and then question 3, and possibly due to time we'll end there, so that I know that at least we have covered Article 17 partly, and then Article 4 too. I know we have covered it. Great. So I know you couldn't get time. Some of you could not get time to go through it. So I'm going to read the questions and then we will discuss what you think would have been your answers. I'm sure we've gone through this one, but I'm taking it again so that will refresh our memory. I said that anytime you are meeting Article 4 question, which is on resident, you either meet it as an individual or you meet it as a company. And if it is an individual, then you know you are going to use Article 4.2. This one there, you need to summarize it in some note somewhere. Summarize it in a very short note that anytime I'm going to answer questions on Article 4.2, then you are going to deal with individuals. If it is about companies, then you are going to use Article 4.3. And the facts will tell you, Article 4.2, we use the tiebreaker rule, the determination of the residence of the individual. We either go by his place of abode, his vital interests, where his economic and vital interests are. That 5 tiebreaker rule, you go through it. If it is individual, if it's a company, then we look at the place of effective management and we go through those factors, for example, where the board of directors meet and all those things. Those are the factors that we use to answer. So that should be clear by now. Okay, so let's look at this question. It's a Munsi Limited is incorporated in country A and listed on the stock exchange in country B. The board chairman of the company, who owns substantial majority shares, lives in country B with 3 other directors. The company has a manufacturing plant in country A. The management decisions for operating the plant are made by 2 directors resident in country A, who meet weekly. They, however, consult the other directors in country B on matters of exceptional importance. The board of directors meet once in a quarter at the company's office in country B. The chairman and 2 other directors attend the board meetings in person, and one director remains at the plant in country A and participates by telephone. Country A treats a company as resident if it is incorporated in country A. Country B treats a company as tax resident if it's central, if its central management and control is exercised in country B. Under country B laws, Munsi Limited is regarded as resident in country B. The tax treaty between country A and country B is the same as the OECD Model Tax Convention. In accordance with the OECD Model Tax Convention on Income and Capital, advised Munsi Limited, a country in which it is resident for tax purposes, and give reasons for your advice. Sometimes we may say that in accordance with the United Nations Model Tax Convention. Please don't be confused. It's just the same reflection. We just tend the other way. There's not much difference. If you have time, just take the two models and then see which templates you prefer. Assuming today you are a consultant and you're advising the government, which model would you prefer? But literally, they are almost the same, with the exception of some few changes. I mentioned the last time that if you are looking at the OECD and the United Nations, the examiner can twist it anyhow, but you don't need to get confused. Just remain with the facts you have. The little variance, I won't even call it deviation or variance, has to do with service permanent establishment. The United Nations treats it, the United Nations model goes a little further to even explain and clarifies it more. So we need to find a little time and look at what that means. So this is a question where two countries, one is registered in the other, in one country, and then the other one is also managed from another country. And the two of them are fighting over the income. Or say, is there any issue? Governor say?
No, please.
Okay. I saw you posted, so I thought that you wanted some issue. So we are just, it's a simple question, half a page, and you are supposed to answer it, determine where the company is resident. So was that where would your mind go? Is it Article 4.1, Article 4.2, or Article 4.3? Where would you have placed it? What in your view? Samuel say.
Timo, I think this should be under Article 4.2, an individual. It is not a company. And the tiebreaker rule shall apply here.
But they mention it's a company. Look at it well.
Oh, okay.
The question, the introduction even tells you that it's a Munsi Limited. It's incorporated in country A and listed on the stock exchange in country B. The problem is that let's take, for example, MTN. MTN is registered in Ghana. Then instead of listing on the Ghana stock exchange, we go and list on the South African stock exchange. And here is possible.
Okay.
So
we need the Article 4.3.
4.3. And immediately your mind goes to 4.3, then you should be able to tell what is at stake here. Is a place of effective management, isn't it?
Yes.
And there are some factors that you should look out for.
From the commentary.
Yes, from the commentary.
To the OECD.
One of them is that you have to look at where the board meets.
The board of directors usually meet.
And then another factor, you don't need to list all of them. Another factor will be where the headquarters is located, isn't it?
Yes, and where the senior executive usually carry their activities.
Yes. And then another factor will be where, which country law regulates the company.
Okay.
And each of these ones, you need to glean it from the facts. Which one is the strongest from your own analysis?
So does it mean when you take, for instance, where the board of directors usually meet, you have to analyze it from the case and then decide whether it is conclusive or not?
Yes.
Before you go to the next commentary.
Yes.
Okay.
So at the end of your analysis, the one that if you have more conclusion in favor of country A or B, then you say that the company should be regarded as resident of that country.
Okay. And tax as such.
Yes. For Article 4, your job is to identify whether it is resident or not.
Okay.
That's all you're supposed to do. When it comes to Article 5.2, your job is also to identify whether that company in question has a permanent establishment.
Okay.
And if you're able to determine it, then your work is about 90% complete.
Okay, so your introduction should be that this is under Article 4.3.
Not necessarily.
Okay.
You really don't necessarily have to introduce it that way, but you can.
To show that you know a company from an individual per the Article 4, 2, and 3.
Mm-hmm, mm-hmm.
If you're able to distinguish it, I believe you have some 2 marks.
You have. But for me, in such a question, it would have been better to even speak a little bit about residents and then why it matters.
Okay.
So introduce generally Article 4 and tell us, what does Article 4 say?
Okay.
Article 4 normally says that the country where you are resident, that is where you should pay tax. Is that not it?
Yes.
That is even from the Article 4.1. Then it tells you that, yes, residents can be complex. And 4.2 now comes to discuss individual. Under what circumstance an individual can have dual residence for tax purposes. Then it goes on to say where the person has a dual residence for those 2 countries. Then the tiebreaker must be used. Then you go and you start. You see the place of Abort, place of economic vital interest. Then you come to his nationality. Even if you apply all those ones, then you can't break it. You can't break the tie still. Then the 2 competent authorities should do a mutual agreement to resolve it. Then you can, in this particular case, Article 4.2, it is irrelevant to go and start at that level with the individual because the question completely does not talk about individual.
It's about
go straight away. It's about a company. Then you jump straight into the Article 4.3. That under Article 4.3, where a company has a dual residence or a company is resident of both contracting state, then the place of effective management, where the company's place of effective management is, that is where the company should be regarded as resident. And how do we determine the place of effective management? Then you go through where the board of directors meet, blah, blah, blah. Then you pick all of those ones, then you analyze them. You understand?
Yeah.
Okay.
But would it be wrong as part of your introduction where you say where a company is resident of 2 contracting states, the tiebreaker rule shall apply? Is it, would you be wrong when you state that?
No. Actually, you need to, before you apply that tiebreaker rule, you really need to mention it. Do you understand? So, such a question like this, and look at the suggested answer. We just mentioned that, we mentioned Article 4, that anytime a person has dual residence and it is a company, then the place of effective management is regarded as a resident, and therefore that country has the right to tax that person. You understand? Yeah. Then you now come and tell us that, however, there are instances where the person will be resident of the 2 contracting states, because I can be registered under the Companies Act, which is in Ghana, and in Ghana, under our Act 896, if I'm registered under the Companies Act, I'm resident. And I can also be registered in Ghana, but I'm managing the company somewhere. Like in this case, the company is registered in Ghana, but listed on the stock exchange in South Africa or another country. Then clearly, if management is exercised in the country in which the stock exchange, they are listed under the stock exchange, then that place becomes a place of effective management, as well as the registration in Ghana. So there's a dual resident. That's why you need to bring the tiebreaker rule to come and apply. And then immediately you mention the tiebreaker rule, then you jump into the Article 3 environment. How do we break the tie? Do you understand it?
Yeah.
So he's saying that, however, where a company is resident of 2 contracting states, the tiebreaker rule shall apply. In that rule, the company shall be deemed to be resident only of the state in which the company has its place of effective management. This problem requires the interpretation and application of Article 4.3 of the OECD model. The commentary to Article 4.3 provides that The following factors should be taken into account to determine where an entity has its place of effective management. Do you see it?
Yeah.
Where the board of directors usually meets. In this case, the board meetings are held in country B. We read it. So this is where you are now coming to analyze it. And we are told from the analysis that the board meetings are held in country B and is attended by all the directors except one who stay in country A and participate by telephone. Is that enough to conclude that where the board of directors meeting is held, which is country B, is where the company has its effective management? Let's take the question again. Muncie Limited is incorporated in country A and listed on the stock exchange in country B. You see, so where the stock exchange is listed, it's MTN, by listed in Johannesburg market. And the meetings, we are told that the meetings are held in Johannesburg. The board chairman of the company who owns substantial minority share lives in country B. He lives in South Africa with 3 other directors. So the directors are there. The company has a manufacturing plant in country A. The management decisions for operating the plant are made by 2 directors resident in country A, who meet weekly. They however consult the other directors in country B on matters of exceptional importance. The board of directors meet once in a quarter at the company's office in country B. Sammy, are you following it?
Yes, sir.
So they are in South Africa and they meet once there. The chairman and 2 other directors attend the board meetings in person. So they are in South Africa, so they attend. And 1 director remains at the plant in country A, let's say Ghana, and participate by telephone. So can we say that because the board meetings are held in Johannesburg, the company is registered in Ghana, and the board meetings are held in Johannesburg, the company should be treated as, is that conclusive enough that the company should be regarded as South African company?
I think the evidence is not.
The evidence may not be too strong.
Strong enough.
Okay. Then you take the next one where.
Timo, please, before you proceed, I wanted some clarity. Okay, so the company is incorporated in Ghana, and so automatically it's resident in Ghana.
Yeah.
No.
Yes.
No. It is incorporated in Ghana, so
it's resident.
Hold on. Ghana. If you take our act, the Income Tax Act, okay, it says that if it is registered in Ghana, yes, it is resident in Ghana. And if it is also effectively managed from Ghana, then it is registered in Ghana. It is resident in Ghana, even if it's not registered in Ghana. Now, the problem is that another country, and look at the question. Look at the question. I'm going to here. Look at here. Country A treats a company as resident if it is incorporated in country A. Do you see it? So Ghana, let's use country A to represent Ghana. Ghana treats any company which is registered in Ghana.
So country therefore, Muse is a resident in Ghana.
Yes. Country B treats a company as such resident if its central management control is exercised in country B. Do you see? So they also come with the same
residency.
Yes, Timo, I get that, but my point is that the first leg is that if assuming country A is Ghana, by virtue of the fact that the company is incorporated in Ghana, automatically is resident in Ghana, then there may be other reasons why the company's management may be exercised in another country. And because of that, we need to now do a tiebreaker. But the fundamental principle is that assuming country A is Ghana, then once the company is incorporated in Ghana, automatically it is resident in Ghana. But other considerations may come in. But that's the foundation.
Okay.
Timo, do you get me? Then we now go and look at whether or not, even though the company is incorporated in Ghana, whether or not by virtue of certain reasons, being that the company is effectively managed from another country, and as such, that country is also treating it as tax resident in that country, whether or not because of that, by mutual agreement, or we have to use a tiebreaker to establish which country should be taxing the company. But I thought that if country A is Ghana, by virtue of incorporation, there's an automatic residency before other things may come in.
Rachel, I hear you, but there are automatic applications where it's a little problematic. I mean, in my view, because if you make that conclusion, it means that all other factors may not count, or that is not what you're trying to say.
No, that's what I'm saying. I'm saying that there's an automatic residency, but because other factors may count, because let's say that another country is also taxing that the company because effective management is being exercised from that country, then obviously the idea of the double tax treaties is not to tax a company or any individual twice. So because Ghana is treating us tax residents, and other countries also treating us tax residents, then the tiebreaker comes in. Either we use the tiebreaker we use by mutual agreement to see, so that we avoid that double tax. But it doesn't mean that automatic residency is not there. That's what I was trying to clarify.
Okay. Then maybe I will rather prefer to describe it as there's that presumption that the company is resident in Ghana. Because if something is automatic, then it's like unchangeable. Anna.
Timo, I think that if you are a resident in Ghana, you are a resident in Ghana. If you're coming to government in Ghana, it's resident in Ghana. There may be a reason why we decide not to tax, but that doesn't mean that because of that's not resident in Ghana. It's resident in Ghana.
Okay.
That's what I mean, with my, as I said, I didn't prepare, so I may be speaking out of.
No, I mean, it's fine. It's fine.
Because we at income tax, I will look at residency for coming from two perspectives.
Yes.
One, incorporated in Ghana, and two, that effective management is being exercised from Ghana. Those are the two reasons. So once there's incorporation in Ghana, automatic residence. I mean, if I were the GRA man, that's what I would say.
Okay, all right. Okay, but I think section 1014 is relevant, just like you mentioned. There are two ways. A is that the company is incorporated under the Companies Act, or the management and control of the affairs of that company are exercised in the country at any time during the year. So this is where we are trying to break the tie. This is our act. Now we go to the fact, and we are told that Ghana treats the company when it is registered in Ghana, but country B also treats a company if the effective management is exercised in that country. So we are now analyzing the two. Who has the rights of residence? Let me put it that way. Should we allow Ghana registration to override the place of effective management? And we have looked at the first one, the board of directors meeting, and we are saying that the fact that the company is registered in Ghana, it is listed in Johannesburg, and the meetings are held by the directors and one person participates via telephone is not too conclusive. We need other factors to consider. And we are going to test this one because we had some senior management as well. The second part says that where the senior executives usually carry on their activities and where the senior day-to-day management of the company is carried on. We are told that the company's business activity is a manufacturing one and is carried on in Ghana, and two directors live here. These two directors make the management decision for operating the manufacturing plants and consult the directors on exceptional importance. Now look here. The management decisions for the operating the plants are made by two directors resident in country A, who meet weekly. They, however, consult the other directors in country B on matters of exceptional importance. Is this a strong indication that the company may be managed from Ghana? Jose? Jose, am I online?
Yes, sir.
It is, isn't it?
No, it is not a strong.
Are you sure? So where do you think the day-to-day management are carried out? Is it in South Africa or in Ghana? The plant is in Ghana. And the directors who are in South Africa, they are consulted on exceptional importance. Read here. Read here. Oh, no. The management decisions for operating. We are looking for where effective management is taking place. And we are told that the management decisions for operating the plant are made by two directors resident in Ghana. who meet weekly. They, however, consult the other directors in country B on matters of exceptional importance. So, Osha, where is the day-to-day activities? Because the commentary says that where the senior executives usually carry on the activities and where the day-to-day management of the company is carried on is a place of effective management. What do you think?
Yeah. I think the condition is fulfilled here.
Mm-hmm.
It is conclusive.
Yes. So there is some conclusive. So somebody can take other view. Okay. Somebody can argue, say, but if they consult the directors actually make the strategic decision. And so if the directors take decision from South Africa, then South Africa should be the place of the real management. That is why the OECD gave us a lot of factors to test. We have tested where the board of directors meets. And we are saying that the fact that even somebody is participating via internet, would you say the person participating has attended the meeting in South Africa? So I mean, if we are having a meeting, now we're UK, now means another person in South Africa, another person in Malaysia, another person in Ghana. Where did the meeting take place?
Where the physical presence is.
No, but you are a director. I am a director. Richie is the director. The three of us are directors. Yeah. Then we decided to have the meeting via Zoom. You are in UK. I am in Ghana. Rachel is in Malaysia. Where is the venue?
All the three. we can't say that there's a venue because.
So you see, you can't say there's a venue. So we can't say where the board of directors usually meet. We can't say it's Ghana or we can't say it's in South Africa because I'm in Ghana. I'm participating via telephone. I mean, so me a director. You see, that's why we are saying the first one, it is not too conclusive because we can't even tell the venue.
Timo, did they say that two directors sit in South Africa for the meetings in country B?
Yes, they are saying that the board chairman of the company who owns the company has. The board of directors meet once in a quarter at the company's head office in country B. The chairman and two other directors attend the board meeting in person, and one director remains at the plant in Ghana and participates by telephone.
So when the majority of the directors sit in South Africa for the meeting.
Yes.
And usually also look at when we are determining venue. It may be an artificial construction, but when we are determining venue, usually we look at where the chairman is sitting. But I mean, when we are saying that we don't really do it because of tax contributing. So I may be wrong. Yes, because sometimes you need to write where the. Sorry.
Are you saying the venue? Where the chairman is where the venue is?
That's why I'm saying that one is just us doing it. So it's not done with tax considerations. Do you understand? So let's say we need to write a venue for the meeting. I don't know if legally it's right, but the company can, in their regulations, say that the venue of the meeting is where the chairman is sitting. Do you understand? But as I said, it's really more of an agreement than something that's done based on law. So that's why I was saying that it may not necessarily, it may be an artificial construction just because you want to write the venue. So we usually use where the chairman is sitting, but not because of tax considerations. So it may not be right. Yeah.
But even if it is okay, fine, we are learning, and it's a good insight. So even if the chairman is in UK and all the other persons are in Ghana, it means that the meeting was held in UK.
And other factors may play. That's why I also asked how many of them were sitting in South Africa. Because I mean, it can't just be one rule. So maybe if the majority of them are sitting in South Africa, I don't know.
And you think it's right?
But I don't know. To use the venue. No, we can't, as you said, it's not conclusive. I'll just share an opinion. It's not conclusive. I think that.
Oh, no, I mean,
because
I've moved from tax, so I'm looking at the legal aspect. Do you think legally it's right to say that?
I don't think that there's anything wrong with the company saying in its regulations that the venue of the meeting shall be, when the meetings are held via the internet, that the venue of the meeting shall be where the chairman is sitting. I don't think there's anything wrong with it.
Okay.
It's really, the regulations is really a matter of contract between the shareholders. And unless there are some tax considerations in it, I don't see anything wrong with it.
Okay.
But on that, I was saying that because there are lots of issues around the board meetings that we are not conclusive, I would say that we need to go with where the day-to-day management of the company is exercised. And I think that there are lots of factors that pull it towards country A. I mean, it's incorporated in country A.
Yeah.
You have the day-to-day affairs being managed in country A. The plant is in country A. And so if you look at where the major source of income is from country A. So I think that there are lots more factors that pull it towards country A than country B. Yeah.
And then even if we are going with the automatic,
is conclusive. I forget.
If we are going with the automatic residence, the registration, you get it.
So I think that if you the way I look at the question is that because if A is Ghana, we don't know if it's Ghana, but if country A is Ghana, I think that there's some automatic residency there because it's incorporated in Ghana. But because country B2 made it, if you look at the factors and we see that no, even though it's incorporated in Ghana, all of its effective management is being exercised from country B. Then in that case, the two countries can agree that in this particular case, because we want to avoid double taxation, we think that the company is skewed more towards country B than country A. And as such, in spite of the fact that country A may have a legal reason to tax it, because most of it is skewed towards country B, it's only right that country B be the country that taxes it. So that's how I see it. But I mean, I don't have my law in front of me, so I may just be saying all kinds of nonsense. Yeah, but yeah, that's it.
All right, cool. Let's look at the last one. Then it says that where the company's headquarters are located, and in which country. I've combined them. So in exams, you can break it into two. You can say where the senior executives usually carry on their business, and then another factor can be where the senior day-to-day management of the company is carried on. Here, you can say where the headquarters is located, and then another one which will be which country's laws governs the status of the company. All of these things are in the commentary. So we are not told where the headquarters is located, isn't it? So, but we are told where the legal regulations governing the company is, which is Ghana, isn't it? Because we are told that the company is registered in Ghana.
Country.
Good. So from your analysis, don't you think that it's more of the factors go in favor of country A?
I think two conditions are met.
Yeah. So the management and then the law, registration and everything. And therefore, for tax purpose, we can conclude that the country that has the residence should be country A. And I'm
No.
That's how we do it. So you just analyze it in that way and then you are done. Then see, it's not difficult at all.
Timo, don't we add that the manufacturing plant is in Ghana in country A, so that to add to the reasons why it should be country A and not country B? I didn't read that part well.
Yes, the plant is in Ghana, but the factor in the commentary did not mention where the assets of the company is located. Richard, are you with me? If you read the commentary,
you're breaking it.
If you read the commentary, there are factors that you should consider in determining the place of effective management. The location of plants or location of assets was not one of them.
Okay, that's fine. But is there factors that are given in the commentary? Is it exhaustive?
We can say the commentary is like an interpretation document. And
yeah, but I just say etc. It just says it ends there.
Okay, Richie, why would you want to add the assets?
No, I think that that's a major source of income. Most of the income of the manufacturing plant is in country A. So unless there's something in country B, the source of the income is from country A.
But if there can be a plant or there can be equipment and it can be remotely controlled, I don't necessarily have to be there. Like
manufacturing plants, it is so fixed. I don't know. I don't know if it's one of those. It's not like they are dealing in they do online sales or something. This is a manufacturing plant.
Yes.
Anyway,
you can have your manufacturing plant and nothing of managerial decisions are taking place. It's just a back office.
Yes, but I'm not looking at managerial. I'm looking at the revenue. Where's the source of revenue? If the plant is in country A, that's where the revenue is being generated from. Aside from managerial, which we've seen that day-to-day management is also there, but I'm just wondering why where the plant is located is not one of the factors that pull.
Okay. I mean, I hear you. It can be argued. It can be argued and included. Maybe Richard will add it to the OECD Ghana team. I mean, it's a good point because if the company is in Ghana and everything is in Ghana, we should consider that one as well.
But that's why it didn't add Esther because it will give you room for you to add your own analysis to it.
Look, you may have a point, Rachel, and I think we may consider it, unless maybe somebody also raises another counter argument and say the mere fact that the manufacturing plants are located over there does not really result in management. Plants are different from management. If you look at our law, it said, let me look at the Act 896. It said, where the management and control of the affairs. So we are talking about management. Rachel, are you with me? Is Rachel online? Oh, Rachel has dropped. So it's about the act is clear, and I'm not too sure whether a court will interpret management and control to include access. Maybe, what do you think? Sam Kisiedu, what do you think?
Hello, Timo.
Yeah, maybe first, and then Kisiedu.
Okay, so I'm also thinking that, for instance, maybe a foreign company can liaise with a company in Ghana and then install a plant here. Mm-hmm. Even though the company in Ghana may not necessarily own that plant. Mm-hmm. It doesn't necessarily mean that once the plant is in Ghana, automatically the major activities are going on in Ghana. Mm-hmm. What if that plant is actually owned by another company outside?
Mm-hmm. Like a third-party manufacturing contractor.
So in that sense, if the question states that maybe the company in Ghana doesn't necessarily own the plants, but then it's owned by another company, will you still want to consider that because there's a manufacturing plant in Ghana, and will you still think about that test?
Let's
hear that the manufacturing plant is owned by the company. It's for the company, so they haven't given you fact that suggests that it's for a third party.
Rachel, the question we are discussing, and maybe I will hear you, and then we'll come and hear from Kisiedu. Rachel, the question is: the law says that management and control of the affairs of the company are exercised. So he's looking at management and exercise of control. And so the presence of assets does not exercise control or management. I don't know what you like. Rachel has dropped. Okay, Rachel is online. Rachel, what do you think the presence of the assets really matters when we are looking at B?
You know, for me, the effective management alone is not.
It's not enough, eh? Rachel, you are off. Okay, let's hear from Kisiedu once Rachel comes back. Kisiedu, do you think the assets, or I heard Rachel saying that management and control alone shouldn't be. We should have had C, location of fixed assets or something like that. What's your view?
Timo, I even had a comment to make on the issue of place of effective management. It seems that that one itself is not really clear. The Article 4.3 says, having regard to its place of effective management. So are we looking at the management of the company as in the central decisions, overall decisions that they make, or management in respect of the day-to-day activities of the company? Because if you look at the question that we have, the management decisions for operating the plant, that one is made by 2 directors who are residents in Ghana. But the board, but when we talk about the management of a company here, I'm looking at it from the board of directors. They sit, the chairman and then the 2 other directors sit in country B, and then another person in country A joins via telephone. So clearly, if you ask me, the place of effective management, if we are looking at it as in the overall decision of the company, that one was being held in country B. But then again, the company is incorporated in country A. And then, like we said, the laws that govern it and all of that is also country A. So yes, I would agree that with the question that we have, the facts are more in favor of country A than country B. Now, when it comes to the issue of the place where the assets of the company is located, I would want to be a strict constructionist, and then I would not extend it to, I will not extend the factors to include the place where the company's assets is located. So I will limit myself to the commentary to Article 4.3, which does not, even though it says etc., actually, it doesn't, the list there is not exhaustive, but I would not want to. Maybe you can touch on it in an exam situation. Maybe I think you can touch on it, but you let the examiner know that even though that is not part of the commentary, you think that it may also be taken into consideration when making such a decision.
Okay, so Kisedu, your concern, I hear you, but you see, the law has been written that the place of effective management, if we go to our Income Tax Act, it's even there, the management and control of the affairs of the company. So we are looking at what determines management and control of the affairs of a company. That's why Article 4.3 gives us a lot of factors to consider. Article 3.4 tells us that, Article 4.3 tells us that when you are considering that factor, consider a number of them. And he said that 1, look at where the board of directors meets, because it determines where control and effective management has taken place. Look at where executive senior managers carry on their activities, where they work. Also, look at where the day-to-day management of the company are carried. Look at where the headquarters is. For example, if you come to MTN, Ghana, MTN headquarters is Reg. And that is where most of the senior managers, most of the things are taking place. Look at which country governs the law. These things will tell you where effectively management is located and control is located. You get a point? So,
Timo, I wanted to disagree with you slightly.
Really?
Because
okay.
it seems to me that the place, Article 4.3 gives 2 factors and says any other relevant factors.
Yes.
It actually says that having regard to its place of effective management, the place where it is incorporated or otherwise constituted, and any other relevant factors. And so it appears to me that the commentary is rather extending the other relevant factors, not necessarily being used as factors to determine the place of its effective management. I don't know if I'm missing the words, but then I feel like place of effective management is one, and then day-to-day affairs being run is also another thing. So the factors in the commentary are just an extension of the 2 things that are listed in the Article 4.3 itself. I don't know if you get me.
Timo, please, I wanted to ask a question.
Okay.
When you look at, I don't know whether it's in the Income Tax Act or in the tax treaty, when it comes to companies, we determine tax residence by place of incorporation and then also effective management.
Yeah, that's
now,
section 1014, the one I'm showing.
Yes. Okay. Now, is it place of incorporation and effective management, or
no, it's all?
Meaning that if we have incorporation in Ghana, we don't even go to effective management. However, I think that effective management only comes in where the company is not incorporated in Ghana, but is being managed effectively from Ghana.
Correct.
I think that's how I understand it.
That's correct. So a company may not necessarily be registered in Ghana, but if all the factors concerning effective management is in Ghana, then you are still resident. You are right. Now, the problem is if two countries are exerting the same right, they are claiming the same right. How do we resolve it?
Exactly.
How do we now
you
determine?
So you agree with me that for country A, assuming country A is Ghana, we have an automatic residency. And then now there's a second point about how to determine who should tax it because of we are trying to avoid double taxation.
Yeah.
Okay, thank you.
I agree with you now.
Okay, thank you.
Okay, so I think time is going. Can we
look at Simon, I wanted to
let's say
something. So if we say that once the company is incorporated, then there is automatic residency. Don't you think it is more appropriate if we say there may be prima facie there is residence in favor of Ghana, and then another country is also claiming?
You are right.
Because if it's automatic, then it means that there is no need for us to do the tiebreaker. Do you get the point?
Yeah.
If you say there is automatic residency in favor of Ghana, then there is no need for the tiebreaker. So I think that prima facie there will be residency in favor of Ghana,
No, what Richard is saying is that there is automatic until somebody raises another claim.
So in this case, that there are two countries that we are supposed to determine. Then we can see on the face of it, by incorporation, it is in favor of Ghana, but not automatic. Anyway, that is what I am also thinking. So that was just by the way.
So you rather use presumption, a rebuttable presumption, eh?
I think so, exactly.
Okay. All right.
Okay, I think I disagree with that, but we can proceed. Because I think that they are residents in Ghana, but the purpose of the double tax treaty is to avoid double taxation. So to the extent that another country, by its laws, can also see that company is resident there, then if that's not the case, DTA doesn't come in at all. It only comes in because there's a potential double taxation. And because of that, we have to go to the tiebreaker. But I mean, at the end of the day, it will come to the same conclusion. So I guess this is really not a very relevant.
Okay. All right. Let's look at the second question. Redeemer. This one, you have to determine which article comes under it. Redeemer is a talented and successful tennis player who often beats Serena Williams anytime they meet for international tournaments. She lives with her family in Ghana. So listen carefully, because it's a combination of residents and Article 17. And such questions carry heavier marks. Redeemer is a talented and successful tennis player who often beats Serena Williams anytime they meet for international tournaments. She lives with her family in Ghana. Her twin children all attend school in GIS, Cantonment in Accra. Although Redeemer has lived in Ghana for the past 20 years, she grew up in UK, where she is a national. She owns a lot of properties in Ghana and UK from her hobby as a tennis player, though she was trained as a tax and legal consultant. Redeemer and her family live in one of the properties in Ghana, and anytime she is traveling, she either stays at various hotels because she can afford it, but when she goes to UK, she stays at one of her properties in London, number 12 Chapel Hill. Redeemer has an arrangement with her younger brother, Raymond, that Redeemer, will retain legal ownership of number 12 Chapel Hill, but that Raymond will have the right to stay at number 12 Chapel Hill throughout the year, provided that Redeemer has a room available to her at all times within number 12 Chapel Hill, where she can leave her bags and shoes anytime she is in London. Redeemer rents out all her other properties in Ghana through the help of Broad Ghana Limited, an estate agency in Ghana. Redeemer spends her time training in Ghana and competing in tennis tournaments in Ghana and several other countries, including UK. She earns a lot of income from a variety of sources, including prize money and sponsorship deals. Last week, she was offered a sponsorship deal with MTN Ghana, a telecom giant in Ghana, totaling $1 million. The deal involves Redeemer exclusively wearing MTN polo cap and mini skirts while competing in tournaments in which she participates for a period of 36 months. Redeemer is the favorite to win a tournament hosted by the Federation of World Tennis, which is to take place in UK come next month. If she wins the tournament, she will get $1.5 million in prize money from the FWT. She has also been asked to act as sports commentator for a televised junior tennis tournament taking place in UK after the FWT tournament. Should Redeemer accept, she will be paid $150,000 for her commentating services. The tax authorities of both Ghana and UK contend that Redeemer is resident in their respective states according to their respective domestic laws. More specifically, Redeemer is present in Ghana for enough days each year and has her family home in Ghana. UK maintains that Redeemer is a national of UK and also owns properties that she stays in when in UK. You are a senior partner of Malta's Consulting, and GRA wants your advice because the issues are a bit complex and needs second opinion from experts like your type. You are required to advise the GRA on the extent to which it would have taxing rights over Redeemer's various sources of income. Ghana and UK have a double taxation arrangement that follows the exact wording of the OECD Model Tax Convention 2017, 30 marks. It's an interesting question, eh? What can you see from it? Can you see Article 17 there? Samuel say, do you think Article 17 is there? Isaac Muchia. Am I online? Hello, am I online?
Yes,
Right.
Okay. Okay. So this is a detailed question. And if you read it and you meet it in exams, you should be happy. Because if you finish solving it, you are on your way to pass. We see Redeemer earning Article 17 income. The problem is that you should be able to tell which income falls under Article 17. So we are giving some figures. Commentating fees. She's going to participate in a commentary. The question is that taxable under Article 17 or is a different income? We are also told that there's a sponsorship deal, $1 million, and it's over 36 months. The contract was signed in Ghana, but she's going to perform in UK. So who should have a right over that income? That 1 million. She's going to play the tennis in UK for 36 months. I don't know how long she will be there, but we are told that the deal is 36 months, $1 million. Should UK also be entitled to the $1 million or part? She also has 1.5 million prize money. Is that also taxable under Article 17? And it's a different income. She has 150,000 commentating service fees. She has properties, rents. How should it be taxed? I must say that in exams, what we are going to go through will not be required of you. The detailed work may not be required of you, but you need to get the salient point. Okay. Now, in this case, UK and Ghana are all exercising taxing rights over her residency. Did you see that? UK maintains that Redeemer is a national, and if you're a national, you are supposed to pay tax. And Ghana is also saying that Redeemer has stayed in Ghana and has a family home, and her children are in Ghana, and therefore any income that accrues to Redeemer should be taxed in Ghana. The two taxing authorities don't know how to deal with the matter, but there's a double taxation agreement between the two, and they've called upon you to address it. So first, determine the residency, because if you're able to determine Redeemer's residency, then your problem is solved. And if you determine the residency, then you now come under the various articles under which each income source is going to be taxed. We have at least 4 sources of income, isn't it? The tennis, the rents, the prize money, the service fees. So what is it about the residents? Wow, it's already 8. Okay, Mabel or Joycelyn, are you there? I need a reader. Joycelyn. Samuel say, can you read for us?
So please, from where?
Can't you see my screen?
Okay, I can see it. Resident.
Yeah.
I read. Resident. Redeemer is a resident under the domestic tax laws of both Ghana and UK. Accordingly, it is necessary to determine which country is the resident state for the purposes of the DTA. From the facts of the question, the DTA between Ghana and UK follows the OECD MTC 2017. Hence, there's a need to consider whether Redeemers has a permanent home in either country. It is fairly clear that Redeemer has a permanent home in Ghana, but does she also have one in UK, as she has a room available to her at all times? There's no mention that Redeemer's brother pays any rent to Redeemer. In order to confirm whether Redeemer has a permanent home in UK or not, it will be necessary to assess to what use the room is put when Redeemer is not staying there, as there is a need for the relevant property to be continuously available. Redeemer's other properties will be unlikely to constitute a permanent home, as they are rented out on what appears to be an arm's length basis and would not appear to be available for Redeemer's use on a continuous basis. Article 4.2, a commentary, commentary 13. Mm-hmm. Without this knowledge, there is a possibility that Redeemer may have a permanent home in UK. And where there is a chance that she has a permanent home in both countries, it is necessary to consider whether she has a Center of Vital Interest, CVI, in either Ghana or UK. Although it is unclear whether she acquired properties first in UK or Ghana, it will appear Redeemer has retained her Center of Vital Interest in Ghana. That's her family home, focal point of her life, and one imagines her belongings are all also in Ghana. Notwithstanding the fact that she may be considered to have a permanent home in UK. That's commentary 15. Whilst it is likely that her Center of Vital Interest will be in Ghana, there is minimal information about her connection between UK, where it is not possible to determine in which country she has her Center of Vital Interest. The Habitual Abort test should be examined. This test looks to the frequency of stays at all Redeemer's various UK properties, as well as all other stays in UK, in order to assess whether she stays more frequently in either country. On the basis of the available facts, it will appear that she stays more frequently in Ghana. The fact that she is a national of UK is unlikely to arise as a relevant factor, as it is highly probable that she will be found to be a resident of Ghana for the purposes of the DTA without resorting to the nationality, that is mutual agreement procedure or tiebreaker test. Accordingly, UK will be the non-resident state in respect of the facts above.
Do you all agree? Who has a divergent view? So from the facts that we have narrated, we needed to test which country has the residents, and we have concluded that Ghana is likely to be the country of residence of Redeemer. Yes, she has properties, she has home to her in both UK and Ghana. But then if you consider all the tiebreaker tests, especially the Center of Vital Interest, her twin children are in your friend is saying, GIS, and they are attending school. Her family home is here. It's likely that, yes, he has his brother in UK and she has one room to her in UK, but all the facts suggest that she's more likely to stay, or she's more likely to have vital interest or connection to Ghana than UK. And therefore, we can conclude that she's more Ghanaian resident tax person than a UK resident. Any divergent view? Joycelyn, you are not talking. Rachel, do you have a different view? Or you would have answered it the same way?
I agree with your analysis.
Okay.
Thank you.
Let's go to the allocation of the taxing right. Now that we know he's a Ghanaian and he has sources of income, what do we do with the allocation of the taxing right? I say, continue to read for us. Samuel say.
Sorry.
Yeah.
Allocation of taxing rights. UK will need to know the extent to which it is the non-resident state for the purposes of the DTA. Has the right to tax, for the purposes of the DTA, has the right to tax the various types of income that Redeemer is likely to derive from sponsorship fees, prize money, and rent. Each of these amounts is looked at in turn, but first, it is important to consider the scope of Article 17 to determine whether any of the relevant amounts fall within this article. Article 17. Article 17 provides that where a resident
derives, resident of a contracting state.
A resident of a contracting state derives income from a relevant performance activity that is exercised in UK. UK may tax the income. As the DTA follows the OECD MTC 2017, there is no need to consider whether the relevant amount arises from a business or employment activity, as Article 17 OECD MTC 2017 is clearly stated to override Article 7.4 and Article 15.2. However, where amounts do not fall within the scope of Article 17, Article 7 and 15 may be of relevance. See Article 17.1, Commentary 1. It is open to countries to restrict Article 17 to business operations only, but there is no mention of this in the fact pattern. Tennis players are expressly included as a category of sports persons. That is Article 17.1, Commentary 5. Sponsorship fees. Whether the sponsorship fees fall within Article 12 or 17 depends on the specific circumstances. For any part of the fee to be taxable by UK, it will need to be shown that the fee is closely connected with Redeemer's sporting performance in UK. Given that the sponsorship arrangement requires Redeemer to wear MTN Limited's apparel in the UK tournament, it will need to be investigated whether some portion of the fees can be connected to a relevant Article 17 activity. On the basis of the OECD MTC, where a portion of the fees can be apportioned to the performances in UK, any remaining fees will be dealt with under Article 7 or 15. No details are provided to make this determination, but the question that will arise is whether Redeemer has a permanent establishment in UK. Where this is not found, Ghana will have the right to tax any relevant business profits. Okay. There is no mention of the use of Redeemer's name or the use of image rights in the sponsorship agreement facts. But if these are included, then it may be the case that these fall within Article 12 as royalty payments. Tournament prize money. Article 17 applies to the prize money as Redeemer derives the money as a direct consequence of performing export capacity in UK. It does not matter who pays the prize money, and so it has no bearing that the $150,000 prize will be paid by the WTF. That's Article 17.1, Commentary 8.1. So UK will be entitled to tax the prize money derived by redeemer.
Please, are we following the analysis? So the question, the first part, we are saying that the $1 million, we should be able to apportion it so that we determine which part relates to the redeemer's performance in UK. Then UK will have the taxing rights. Second part is the prize money. We are told that the World Tennis Federation is the one going to pay if she wins. So we are clear in our mind that that prize money will be taxed in UK. We are now coming to the commentators, the commentary, the amount she will get from the commentary. Continue.
The question is loaded, Papa.
That's why that's why I'm saying that if you get a question like this, the residents will give you marks. You can get it like maybe 35. I remember was it in the early part of the years? One question can carry like 40 marks.
Wow.
And the students were complaining, say that question, or if you can't answer, you are So I think we are moving away from that.
Okay. Sports commentator fee. Do these fees fall within Article 17 or another article? More specifically, there is a need to establish whether redeemer's fee is derived from a performance in UK. According to the commentary, where a sports person comments on a sporting event in which they are not taking part, that's Article 17, does not apply to any income derived as a result. See Article 17, Commentary 9.1. The DTA follows the wording of the OECD MTC 2017. Therefore, UK is unlikely to have the right to tax these fees under Article 17. Amount falling outside Article 17 may nevertheless be taxed in UK if redeemer is found to have a PE under Article 5, and so taxable in UK under Article 7.4, or where these fees can be cut by Article 15.2 as employment income. There are insufficient details to make this determination, but argument can be made both ways, such that UK may have the right to tax these fees under one of these provisions: rents. Any rental income derived, considering any allowable expenditure by redeemer from properties rented out in UK on an arm's length basis, may be included in redeemer's UK tax return. That is Article 6.1.
We have not done Article 6, so we will come and look at it in our next listing. Okay. Mm-hmm. Continue.
The use of the word may result in Ghana also being permitted to include the relevant income where it provides relief from double taxation. However, the required only specifies an assessment of UK's situation. Conclusion. On balance, it will appear that UK has taxing right over the rental payment. Potentially, a portion of the sports sponsorship fee, although the specific agreement will need to be examined to determine what proportion is connected to UK performances and over what period. And the prize money, but not her commentating fees.
Good. So this is how you conclude it. We do not expect you to go through all this thing. Yes, in a summarized version, because if you are writing all of this in the exams, yeah, you will die. But follow the trend. First, determine the residency of the person by using Article 4. When you've identified the residence of the person, then you come and look at the various income, the rent, the prize money, sponsorship, and all those commentating fee. For income, who has a taxing right? If it falls under Article 17, which is the prize money and then the sponsorship fee, the sponsorship deal is over 36 months. So UK cannot say they are taxing everything. So we need to examine the contract and look at what proportion can be allocated to UK. Because the Article 17 says that if you perform, if you play your sports in our country, we are going to tax you. So the 36 months is a deal. And so we need to determine which period covers that, and then UK can have a taxing right over it. Then the remaining ones will be taxed in Ghana. Look, sports taxation is very interesting. Read the case of Usain Bolt, the Olympics 2012. The guy said he was not going to run again because UK was taxing all the money. They had to plead with him, say, Olympics without Usain Bolt is not Olympics. And eventually he came. Read it. You can Google it and read it. And then Andre Agassi is also one of those highly highlighted cases in sports and taxation of sports income under Article 17. So we will end here, but don't forget that, yes.
Timo,
yes.
Before you go, for the sponsorship fees, do we not look at how related it is to a particular event that is going to happen in a particular country?
Exactly, we do. And in this case, we are saying that the deal requires that anytime Redeemer is playing, she must wear MTN polo shirt and then the miniskirt. So whilst in UK, she's still wearing it. So UK government will come and say that because you are earning this income from playing in our country, we are going to tax you. But it's $1 million over 36 months. And so we need to apportion the income and find out if it is a week or whatever. Then we know how the apportionment will be done. Then we give some of the income to UK to tax.
Okay, that's understood. Thank you.
Okay, so this year is your friend is saying World Cup. Don't be surprised a question comes under Article 17. So look at it from different angles. And for me, the commentary is very important. So I would want you to take your time and read the commentary. You see that all this things that we said, they were all lifted from the commentary. And then we'll make progress. So we'll end here, it's 8:30. We'll end here and then we'll continue with the questions and answers on the oil and gas. Please, I have skipped 2 questions from the international taxation. You see the Tenki project. I've still not received any attempted question or attempted answer. So I'll urge you to take your time and look at it before we come and discuss it. And then when we finish, we'll fix a time, one of these during the week, one evening. Then I believe it's fair. One evening when we are 1 hour cry is okay. Then we'll discuss the answers and then we go so that it doesn't become said. We are doing everything, putting it to the end of the period when we are going to write exams. Any question?
So when are we doing the oil and gas?
Should we agree on Wednesday, Rachel? I don't normally fix in class in the evening because of the lawyers. They'll be preparing their brief for the following day.
How about Tuesday?
Tuesday is fine for me.